As we discussed in our last video, the business that you're operating or that you're working in is in a legal environment. It's in a political and legal environment. And today's lesson is going to be a little bit like a Poli-Sci 101 or an Intro to Constitutional Law lesson, but that's because it really requires one to understand this entire complex system so that you can make better choices within the business environment. Many nations, such as Ireland, England, Italy, these are essentially what we call unitary nations, which means that the federal government has a large amount of power, and the local governments, whether they be counties or in France's case, départements, whatever they call them, they're largely administrative units of the federal government, and they take their marching orders from the federal government. The United States, Canada, Germany, they're all what we call federal systems. And by a federal system, what I mean is there is a shared power, or even a struggle sometimes, between the federal government and what their rights and responsibilities are, and the local governments or the state governments, in Canada, the provincial governments, as to what power and authority they have to enact laws that may be at odds with or different than the federal government. So the United States is a federal system, and we were designed that way on purpose. And not only are we a federal system where there is this tension between the federal government and the states, but we also have a separation of powers within the federal government between different branches, so that there is always a tension, and there is always a situation where two or more branches of government are checking the other. And so it's a lot more complex than just asking what is the law. And that's one of the reasons why it's not always clear, as these different branches and levels of government are engaged in this very messy dance as to who has what to say over what particular topic. In the United States Constitution, we are divided, as I'm sure you all know, between a federal and state government. At the federal level, and let's just talk about the federal level right now, the Constitution, the first 3 articles, tells us how this federal government is going to be divided up to create this tension. Article 1 of the Constitution says that all legislative authority at the federal level is vested in Congress. That means Congress, and Congress alone, has the authority for making statutes that can be enforced. And the Constitution lists what those rights are. In other words, it says that the federal government, or the federal legislature, in this case Congress, can establish a postal system and post roads. It can declare war. It can borrow money. It has the power of taxation. For our purposes, probably the most significant clause is the one I mentioned in my last video, and that is the Interstate Commerce Clause. That Congress has the authority to regulate commerce among the states. And this is a power that Congress has used on a wide variety of topics by saying that it somehow, whatever law they want to pass, somehow affects or impacts interstate commerce. And we're going to be coming back to this over and over throughout this semester. Article 2 of the Constitution tells us that there is an executive branch, who you know as the President. The job of the President, the authority of the President, outside of being the Commander-in-Chief of the military forces, is not to make laws. The executive branch is not given any authority to make law. Their authority is to carry out the laws that are passed by Congress. Now, in order to do that, the executive department under the President has a whole range of agencies, many of which you've probably heard of. The Department of Labor, the Department of Commerce, the Environmental Protection Agency, the Occupational Safety and Hazards Administration, the U.S. Census Bureau. All of these federal agencies come under the executive branch, and it's the president's responsibility to make sure that these particular agencies are carrying out the laws passed by Congress. Now, when those agencies are often in the position of being forced to make more specific regulations. And I'll give you a very good example of this, because it resulted in a legal case that you will, without a doubt, hear more of in the next few years, if not your lifetime. The Environmental Protection Agency, well, Congress asked the Environmental Protection Agency, they passed a law saying that the EPA should come up with rules and regulations for permits for smokestacks, for air pollution sources in what they called stationary sources. In other words, not a car, because a car is not stationary, it moves. But Congress said the EPA shall develop regulations for the issuance of permits for stationary air pollution sources. Well, there was a famous case involving the Chevron company, where Chevron had a large plant with multiple smokestacks. And they had a permit from the EPA, and they complied with the permit, to release no more than a certain amount of air pollutants. Well, Chevron decided to rework some of their smokestacks in this plant. One of those smokestacks produced a lot more pollution than it had before. But the other smokestacks actually produced a lot less, so that they did not go over the limit that was on their permit. They got into a tangle with the EPA because the EPA said a stationary source is every individual smokestack in your plant. Therefore, the new one that creates more needs to be permitted. Chevron said, no. We're one factory. This is one plant. We are a single stationary source. This went all through the federal court system and finally got to the U.S. Supreme Court. Now, Congress never, in the passing of a law, they never defined what a stationary pollution source was. They left it there. So when the EPA was making their rules, they decided that even if you're one plant with multiple smokestacks, every single smokestack requires its own permit. This went all the way to the Supreme Court. The Supreme Court decided in a widely criticized and highly controversial 5-4 decision. They decided that the court should give deference to administrative agencies when writing rules and regulations. They essentially said, we don't know what Congress had in mind. It's hard to know what anyone had in mind, but the agencies made a regulation that was a rational result of what they were charged to do. Therefore, we will defer to the agency. And by the way, these laws, these regulations that agencies write, is called administrative law. There are many people who said, well, that makes sense, because Congress doesn't, for all the words they use and all the bills they pass, they leave a lot of things unsaid. And that if an agency is going to carry out the purpose of the legislation, they need to have some discretion as to how to do that. Others who criticized it said, no, what we have done is we've given Congress the authority to pass laws, but essentially they're passing the buck to the executive branch, and the executive branch is making regulations, and these are made by lifelong agency employees who are not elected, who are not accountable to the people, and are not even in the legislative branch, and they're making law. As I said, this is a 5-4 decision. It is often referred to in shorthand as the Chevron deference in legal circles. And it comes up over and over and over again. And one always wonders, is this one of those decisions that's going to be tweaked or modified or overturned soon? And it's important for you in business because, frankly, 95% of the interactions that you are going to have with government, it's not going to be with legislators or governors or presidents or any of these major high-profile elements of our government. It's almost always with administrative agencies. And what authority administrative agencies have to make rules is a constant source of tension and a constant issue within the court system. So in the short term, when the Department of Health says this is what you must do, that's pretty much what you must do, but that may change if it's ever challenged and goes the route of legal challenges. So that's the legislative and the executive, and then of course you've got a third branch of government, and that's the court system. And the court system is supposed to be the arbiter of disputes between citizens and each other, between citizens and their government, and even between two different governments. There are court cases where, there was a recent one where Alabama and Tennessee were at battle over water rights on a water body that crossed their boundaries. So the court's there to resolve these issues. Now, just to make things more complicated, you've got three branches of government, each in tension with each other. The court system itself is very, very decentralized in the United States. If one is bringing suit in a federal court, the very first court you go to is called the district court. Every state has at least one district court. For instance, Massachusetts is the United States District Court for the District of Massachusetts. Now, there may be a number of court buildings throughout the state, but it's all considered the district court, and it's all one district. This is what we call the trial court. And if you go to a federal trial, this is where you may have a jury. This is where all the issues of fact come out, and you have your evidence, and you have your witnesses, and people are trying to figure out what exactly happened in this case. Federal courts have very limited jurisdiction. If you're a resident of Massachusetts suing a resident of Massachusetts, and it's a Massachusetts law, you're not going to end up in federal court. You're only going to end up in federal court if there's a federal issue involved, or if you're suing someone from Vermont or New York or some other state, and there's a cross-state issue going on here. And federal district courts will not look at criminal cases either, unless it's the federal government bringing the case, then they will. So it's limited jurisdiction. It's the lowest level of the federal system. As I said, every state is basically one federal district, except for the larger states. So New York has got 4 different federal districts in it, with 4 different federal judges. When you don't like the decision that is arrived at in the district court, you then go to what's called the circuit court, which is where you appeal to. In the United States federal court system, circuit courts are groups of states that have a panel of judges who hear the appeal. And these are called circuits. It's almost always referred to as the circuit court system. The First Circuit is Maine, New Hampshire, Massachusetts, Rhode Island, and Puerto Rico. Vermont and Connecticut are actually in the Second Circuit with New York. There are 13 circuits around the United States. Each one, if you appeal, you have a panel of judges before you who pretty much are like taking the place of a jury. But you cannot appeal facts. They've already been determined at the trial court level. In other words, if the trial court decided that Joe did forge the contract, that's not a decision that can be appealed. Questions of fact are settled at the trial court level. The only thing you can appeal are issues of law. So, for instance, the trial court may have decided that Joe forged the contract, but you might be able to appeal the fact that the judge gave the jury incorrect instructions, or that evidence that was used to reach that factual conclusion should not have been admitted in the first place. So there's legal questions and there's factual questions. You're only able to appeal legal questions, and then the appellate court makes their ruling. Once they make their ruling on that fact pattern, that is the general rule for that fact pattern throughout the district. So if a district court, if the circuit court rules on a main case that electronic signatures are not valid on a particular contract, that will hold, not just in Maine, but in New Hampshire and Massachusetts and Rhode Island and Puerto Rico as well. So that's how the circuit court operates. The last level, of course, and the highest level, of course, is the U.S. Supreme Court. At the U.S. Supreme Court, they are taking cases on a very, very selective basis. So, for instance, if the First Circuit decided electronic signatures are invalid, and the Second Circuit decided they're invalid, and the Fifth Circuit decided they're invalid, there's a lot of consistency at the circuit court level, the middle court level. Supreme Court is probably not going to take that case. But if they come to different decisions, then the Supreme Court realizes they've got a serious issue of the law that they need to settle for all of the circuits. This is how Obergefell v. Hodges, which was the case that legalized same-sex marriage throughout the United States, got to the Supreme Court. Most of the circuits had already said you cannot discriminate based on gender. One of the circuit courts said, yes, you can, because marriage and the requirements for marriage are state issues, not federal issues. The Supreme Court needed to take that case and step in and make a decision. As a matter of fact, fewer than 1% of appeals to the Supreme Court actually get taken up. The last numbers I have, in the last term, the Supreme Court accepted 125 cases out of 7,000 that were appealed, because there's only so much work they can do. And they are looking for cases where there is real conflict in the law, where there's a real difference of opinions between the judges at the district and or circuit level, and where clarity is absolutely needed for consistency. That's all the federal approach. Now we have a parallel universe, because the states also each have their own governmental systems and their own rights and responsibilities. And there are certain topics that have traditionally been the right of states to determine, such as education. One state may require you to be in school to 16, another 18. One may require 4 years of math, one might require 1. Education has always been a state province. And a lot of the issues you will have as a business dealing with government are going to be state issues. What does the state health department require? Do I have to have 12 sinks? Do I have to have someone certified and serve safe? Do I need a license for this business or not? These are all state issues, even though the federal government has the right to regulate interstate commerce. So with all of these issues being legislated at the state level, and with the federal government having the right to legislate interstate commerce, you can see how so many business law decisions are going to be decided based on the conflict and the nexus of federal and state power rubbing against each other. In the state system, you've got your executive who has to carry out the laws, you've got your state legislature who makes the laws, and of course you've got your court systems. When looking, and it's just a little footnote here, when looking at the names of state courts, don't assume anything is obvious, because state courts are named in ways that are not intuitive. In Massachusetts, the lowest court level, this is your trial court level, you're not going up to the top on appeal, your lowest court level is called the Superior Court. In New York, the lowest court level is called the Supreme Court. Totally the opposite of what you get from the federal level. So whenever you're looking at cases that are state cases, it's really important not only to know what court the decision was held in, but also what level, what jurisdiction is that particular court. Because having a highfalutin name doesn't necessarily mean they're the court of last resort. Now, let's go back to this conflict between U.S. and U.S. federal and state statutes, especially in the business arena. The best way to think of this is that when the federal government enacts laws that affect business, that are business oriented, think of the federal rule as the minimum threshold. Okay? I'll give you a good example that you're probably all familiar with. The federal government may pass a law saying that the minimum wage across the country shall be no less than $12 an hour. That would be the law in every state. It does not stop a state, however, from saying our minimum wage will be $15 an hour. And so this is where the federal government is exercising the Interstate Commerce Clause powers to provide a minimum threshold. But the states can go above that threshold. The same thing is true of voting rights. The U.S. Constitution says that you cannot deny anyone 18 or over the right to vote, with certain exceptions. What if a city wanted to allow 16 and 17-year-olds to vote in their municipal elections? Can they? Well, a lot of people would look at that and say, that's ridiculous. The Constitution says 18 is when you vote. No. Federal Constitution says you cannot deny the right to vote to someone who is 18 or over. If a locality says 16-year-olds can vote, they have not denied the right of anyone 18 or over to vote. Therefore, they can do it. And so a lot of the issues that we will see in this term are issues where the federal government has said one thing, but the states, for whatever reason, have decided to go beyond. Now, the tension between federal and state, the tension between executive, legislative, judicial, the tension within the judicial branches between one circuit and another, often come together in Supreme Court cases that make a lot of news. And so I'd like to end this lecture by talking about one of the most controversial decisions in recent time. And again, because it's controversial, you'll probably hear it referred to again. And that's Kelo versus New London. Kelo versus New London was decided in 2005. At the time, the city of New London was concerned with blighted areas of the town. It was economically run down. So they came up with a development plan to reinvigorate the economy of New London. And part of this plan called for taking private property in a particular neighborhood, which we call eminent domain. Under the federal Constitution, private property shall not be taken for public use without just compensation. And so there's two really important operative clauses in that. You can't take private property, A, for public use, B, without just compensation. The City of New London, after they developed this plan, started negotiating with Pfizer Corporation. And they came up with a scheme for Pfizer Corporation to be allowed to build all sorts of buildings on this enormous piece of land for their economic development. And to do that, the city needed to condemn an entire neighborhood of houses. This was a long time neighborhood. Some people had lived there multiple generations. Most people were offered a particular cash settlement and said, okay. 9 residents said, no. We've lived here for generations. My brother's here, my grandmother's there. We're not moving. They sued the City of New London. They lost in the Connecticut courts, going all through the court system. But the Connecticut courts themselves were divided on this issue. There were majority decisions and dissents. It finally ended up at the Supreme Court. The City of New London argued that we paid them just compensation, so that's off the table. The question turns on, was the eminent domain for public use? And New London said that, well, we're giving it to a private corporation, but there's going to be a public benefit or a public purpose because it will increase the tax base of the community and it will help economic development in accordance with our plan. That's good enough to be considered a public use. And obviously the homeowner said, no. This is not a public use. This is not taking our houses for a park or to build a dam to prevent flooding. And there are a number of cases that the court looked at, going back through history. The court has taken land for railroads. During the 1800s, they took a lot of land for railroads, which were private corporations, but there was a significant public use in that the public could ride the railroads. Same thing with taking someone's property to build a road for the public to use the road. In the case of the Pfizer Corporation, the public was not being given admittance to that land. It was a purely private economic development. The court decided, again, 5-4, incredibly controversial decision, one of the most controversial decisions in the last few decades, that the U.S. Constitution does not forbid the taking of land for general economic purposes, even if it's going to benefit a private party like Pfizer Corporation. Because in this case, there was general public benefits. The dissent in that case said, no, you just changed the wording of the Constitution. It says you can take it for public use, not for public benefit or public purpose. And this, as I said, this was an incredibly controversial decision, but it didn't end there. Because of the system we have of checks and balances and federalism, the following year, President George W. Bush at the time issued an executive order. And remember, an executive order is something the president can issue to federal agencies under his jurisdiction to carry out the law. He issued an order prohibiting the federal agencies from commencing eminent domain proceedings against any private property for the purpose of economic development or to transfer to a private party. Now, it still happens all the time in the federal level. The taking of private land to build the wall under the Trump administration between the United States and Mexico is a prime example of that. But that was considered public use and not for private economic development. On the state level, by 2019, 44 5 states passed legislation within their home states saying that eminent domain could not be performed by any state agency, any state government or counties that are part of the state government or cities for the purpose of economic development or to transfer to another private party. So this takes us back to that threshold question. The federal government, in the Kelo decision, the U.S. Supreme Court said the federal Constitution permits the taking of private land for economic development purposes. There's nothing in the Constitution contrary to that. That doesn't stop the states from saying, however, we are going to afford additional protections. The Constitution might not prohibit it, according to the Supreme Court, but our state prohibits it. And so even though the Kelo decision opened the doors for eminent domain for private economic development in 45 states, it's essentially a moot question because the states themselves went above and beyond and said, well, we'll outlaw it ourselves. The biggest example of a state that did not do this, New York State. New York State has a history of some of the wildest, largest eminent domain proceedings in the United States, almost all for economic development and almost all involving the transfer of people's property to private developers. The Barclay Center, the Hudson Yards development in Manhattan, Madison Square Garden and Penn Station. And as I am making this video, there are 2 enormous cases in upstate New York, one in Syracuse and one in Utica. The one in Utica is for a private hospital that wants a parking garage. So they've asked the county to condemn the neighborhood next to them so they can build a parking garage. And the argument has been, well, there's a public benefit here because even though it's a private garage for us, it'll help out with traffic on the streets. And in Syracuse, there was an industrial park that has been vacant for 20 years, not a single tenant. And the county decided that if they expanded the park, they'd get some big tenants. And so they're looking to take an entire neighborhood. From a judicial perspective, the state will not stop them. And it is permissible under the federal Constitution, under Kelo. So, from a business law perspective, if you're a big company and you'd like to condemn some property for some great development, New York is your place to go. On the other hand, if you want to defend your property against eminent domain for someone else's economic development, almost anywhere but New York is the place to go. So that was just a brief overview as to the levels of government, the tension between them, and how different levels of government and different branches of government will jockey for position in shaping the law, which once again comes back to my theme for this semester, and that is asking, well, what is the law in this case? There's never a simple answer, and it always is in flux, and it's always changing. Well, thank you, and I'll see you in the next lesson.